Hello, everyone. My name is Imran Ahmad. I am a partner here at Norton Rose Fulbright Canada. I'm absolutely delighted to be here with my very good colleague, Sarah Nasrullah, who's a senior lawyer in our group and who will be talking on a monthly basis with us going forward on a new segment we're going to be starting called Privacy Primers. And really, the goal here is to share some insights over the next 5 to 8 minutes or so in terms of key elements or fundamental elements of privacy law in Canada. So, this is going to be our inaugural session. So, welcome, Sarah.
Thank you so much. Happy to be here.
Yeah, looking forward to the conversation. So today's topic is going to be the legal basis of processing under the proposed bill C-27, which is still before Parliament, but I know you're going to talk a little bit about that. So maybe setting it up for our audience, can you tell us where we at with C-27? What is it and where is it at in the parliamentary process?
So, as you all know, the Government of Canada tabled Bill C-27 back in 2022, and it introduces three proposed acts: the Consumer Privacy Protection Act, the Artificial Intelligence Data Act, and the PI and Data Protection Tribunal Act. So, right now it's with the Parliament, and it was referred to the Standing Committee on Industry and Technology right before the summer break. And hearings are expected to start sometime this fall.
Got it. So a chunk of it is going to be amending or replacing PIPEDA essentially. Can you
That's
tell
right.
us a little bit about the main differences between what we have right now under PIPEDA and what this new piece of the CPPA from C-27 is going to be?
Okay, so there are some big differences between PIPEDA and C-27. So the first is the legal basis of processing. So PIPEDA was a consent-based regime, and so is C-27, but there are some nuances here that have been crystallized in the bill. And there is also a longer list of exceptions that companies can rely on. Previously, under PIPEDA, there were about 5 of them, and now they've expanded significantly more. Uh, at the same time, individuals have been given additional rights. There's the right to deletion, there's the right to data portability, the right to an explanation whenever a significant decision has been made about them using an automated system. In addition, we also have the private right of action. And now under C-27, anonymous and de-identified information have been defined. De-identified information will be in scope of privacy laws, whereas anonymous information will not be.
Yeah, that's really helpful. Obviously, with PIPEDA, the commissioner had issued various guidelines. What we've seen with C-27, or at least the portion that touches on CPPA, there's a lot of codification of some of the best practices or guidelines that the commissioner are providing. I think you touched on a few of them. So maybe what you can do is when companies are looking at legitimate interest, in particular, and the basis for legal processing, what kind of analysis do they need to go through? Can you share your thoughts on that piece?
Okay, so I think this is going to be a bit of a lengthy exercise for companies. So whenever you are collecting new data elements or you are thinking of using the existing ones in a different way, you have to go through a somewhat lengthy exercise. You have to conduct a legal analysis to make sure that you can do it, but how can you do it? So for example, there are 3 steps that you've got to think about. The first step is, will a reasonable person consider this appropriate? And that's codified under Section 12. And they've given us factors to go through to determine what that is. So for example, the factors that you will take into consideration when you're thinking of the new use case is the sensitivity of the personal information. You will also think about whether these purposes, they represent the legitimate business needs of the organization. And the third is it effective? Whenever you're collecting, using, disclosing this, is it really going to be effective in meeting those needs? The fourth is, are there any less intrusive means that you can rely on instead? But the good thing is that legislation has given us language that says at a comparable cost and with comparable benefits. So they're not really expecting us to go way all out and do something different, but within the same realm of your use case, if there is within the same cost level and benefit level, if there's something you can do that is less intrusive. And the fifth and last point to consider is whether the individual's loss of privacy is proportionate to the benefit in light of the measures that you're taking. So if you go through this 5-step analysis and you consider that this is reasonable, a reasonable person is going to think this is appropriate. So then you can move on to step 2. And step 2 is, does this use case fall under an exception? So C27 gives us a list of exceptions to go through. They're too long to go through here, but I'll mention two of those that I think are very important. First is business activities, and the second is legitimate interest. So if you can put your use case under those two, good. But if you can't and you don't meet those criteria, then you've got to go to step 3, which is, have you obtained the right consent? And what I find very interesting here is that the language says consent must be expressly obtained. Unless you can justify that it's okay to rely on implied consent, taking into account the reasonable expectations of the person and the sensitivity of the PI. So what I find interesting here is that the onus seems to have shifted a little bit. Now it's like expressed by default, and you can still rely on implied consent, but you've kind of got to justify it, taking into account the
Hmm.
sensitivity of the PI and the reasonable expectations of the person. So this is a bit of a lengthy analysis, but these are the 3 steps primarily that you've got to go through when you're considering new use cases and new PI.
So I love the fact you've broken this down into 3 relatively straightforward steps. I know there's a lot of detail that goes into each step analysis, but I think this, just for our audience, is a great starting point for them to start thinking about looking at these legal bases for processing. A term that comes up a lot is legitimate interest. You've touched on that a little bit, and then what are business activities that we're engaged in? Can you sort of explain the difference between the two, or are they the same?
Okay, so that's very interesting. Let's go through. This is going to be completely new to the Canadian regime, so I think it warrants a discussion. So let's go through what's common. So there's 2 things that's common between both these exceptions. The first is that it has to be expected by a reasonable person. The second, and one that I find really interesting, is that you cannot rely on these exceptions when you are going to influence someone's behavior or their decision making. So that is common between both of them. So if you go through your analysis and you say, okay, we're fine with these two, we're not influencing anyone's behavior or decisions, this is reasonable, then we can come to what's different between the two. So for example, a business activity, you can rely on this exception when you are doing whatever is necessary for you to provide a product or a service that an individual has requested from you. The second is it's necessary for the safety of your products and services. The third, and they've used the word and, is that it's necessary for your information systems and network and security. So for you to rely on business activities, all 3 of them have to be met. So the way I see companies using this going forward is that this is going to be used for a core set of your business activities that you're currently undertaking, that you don't see changing very often, and that is your core business in the sense these are your products and services that you are supplying to your existing customer base. Uh, the second is legitimate interest. Moving on to that criteria is a little bit different. So if you're going to rely on legitimate interest as an exception, you have to first go through another assessment or another legal exercise where you try to identify any adverse effect that could be
Hmm.
on the individual. And then the next is you've got to go through the exercise and try to think of ways to mitigate those risks. So if you've done that, then I think you can rely on legitimate interest as well.
Very good. That's very, very clear. Is there a quick use case you can walk us through that may be helpful for the audience as they're thinking through these issues?
Yeah, so I think it's like C27 and all of this legal analysis is becoming pretty complicated. So I think it's very useful to go through a use case. And one that I find very interesting is, for example, as we know, AI is rampantly being used by a lot of businesses. And for example, you're in-house and your business comes to you and says, we know of a vendor who is supplying us with AI-based collaboration tools to monitor employees during meetings. Can we use this? So you'll have to kind of go through an exercise, and some of the questions you'll ask is, well, it depends. What type of PI are you using? What are the data elements that you're collecting? The second is that what exactly are you using this for? So say they come back and they say, we're going to be using their facial expressions. We're going to be monitoring them during meetings. and we're going to be using their voice, the inflection, the tone, the emotion. And then what this tool is going to do is at the end of it, it's going to give us some matrix. It's going to help us identify which employees are team players. And it's also going to, on an a personal basis, it's going to tell us how key decisions are made in this company. So that sounds like very useful information for a company to have, but of course, it it should also get some alarm bells ringing because you're starting to collect some biometric information like voice prints and facial expressions. Um, so I would say that for this, like to go through all the steps, um, I would think that you cannot really you. I'm going to say that you can't really rely on the exceptions of business activities or legitimate interest because as we know, if you're going to use this information to influence someone's behavior or decisions, you can't rely on these exceptions. You'll have to uh, because I think that if you're starting to monitor employees, this information could ultimately be used in their productivity sessions or in their annual review. So I'm going to steer away from those exceptions. And because you're collecting biometric sensitive information, I'm going to steer you towards express consent and like obtaining express consent from those individuals to see if they're okay with being monitored this way.
Hmm. So just that example is really interesting because it touches on biometrics, potentially AI, obviously the privacy issue that you brought to the fore. So the analysis is not always straightforward. That it
Exactly.
falls under an exception or not is TBD.
Yeah.
I think this has been helpful. That's all the time we have today, Sarah. But I think
Yeah.
for our audience, hopefully this was a good starting point when we talk about uh, the legal basis for processing under this new bill. And there's going to be a lot more to come. I'm looking forward to our monthly check-ins, which are going to be our privacy primer sessions. And for our audience, please tune in every middle of the month where Sarah and I are going to get together and put these little videos out that may be helpful for you and your team to share amongst yourselves. And then also, every month, as the norm for a while now, David Sivaratnam from our knowledge management team will be joining me to talk about developments in the Canadian privacy landscape, what happened in the prior months. So looking forward to be back with everyone. And Sarah, thanks again for this great overview.
Thank you. Yeah. Pleasure to be here.
All right. Thanks, everyone. Bye for now.